happy Valentine's Day and happy Family Day, everyone. Today, I have our expert at our firm, Otto, who is the partner at our firm who's in charge of family sponsorship. And today, we wanted to give you some pointers about spousal sponsorships. So first off, Otto, who qualifies for the spousal sponsorship category?
So spousal sponsorships are probably my most favorite type of applications because it's really bringing families and spouses together. So in Canada, we essentially have 3 different types of spousal applications. So the first is the one that everybody knows about, marriage. So if you're married, you're a Canadian citizen or permanent resident, then you can sponsor your partner who's a foreign national. The other ones that are a bit less known is common law sponsorship. So Canada has this very weird thing for immigration purposes that if you live together for more than a year in a marital-like relationship, you automatically become common law. You don't have to go sign a paper at City Hall. There's no document that comes. It just happens. And so if you're common law, then you're able to sponsor your spouse. And the third type that we have is a much less known one, but it's called conjugal sponsorships. And conjugal sponsorships were designed in the late 80s, early 90s, and they were to respond to same-sex relationships, which at the time couldn't become common law or married. And in many jurisdictions, as we know around the world, you can't get married if you're in a same-sex relationship. But it's kind of expanded a little bit, and it's for individuals who, for some reasons, usually legal reasons, are unable to either live together or to get married. You can do a conjugal sponsorship.
Let's say you're in one of these relationships where you can get sponsored. What are the responsibilities of the Canadian sponsor? What do they have to do if they want to participate in this program?
Yeah, so that's a great question, and I often get asked, the first question is, do I need to be making a certain amount of money to sponsor my partner? And the answer is actually no. There is no set amount. So for example, in parental sponsorships, there is a table, and based on your family size, you have to be earning that much income. But in spousal sponsorships, that is not the case. However, saying this, the government does want you to be able to support your spouse for at least a 3-year period. So you will be signing a document, and what that document says is that you are financially responsible for that individual for at least 3 years. And that's whether you're in a relationship or not. So if there's a breakdown in the relationship, you will still be financially responsible for that individual. And when we say financially responsible, what that means is if that individual goes on social assistance, meaning welfare, then you will owe that money back to the government. So the major responsibility that you have is that you're financially responsible for that individual for 3 years, whether you're in a relationship or not.
What if the sponsor themselves is currently on social assistance?
So that is a bar to sponsorship. There are ways around it. You can ask for humanitarian and compassionate exemptions to it. And officers will look at the reasons why you are on social assistance. But generally, it is a bar. And the reason that it's a bar is because when the officer's assessing, are you going to be able to financially take care of somebody else? They want to know that you're financially taking care of yourself first.
So let's say you're eligible as a sponsor, you're ready to sponsor. What considerations should the applicants have when they're deciding how to go about it? So in Canada, we have 2 systems for spousal sponsorships, right? You can do inside Canada or outside Canada. Can you kind of explain what the difference between the 2 are and what considerations people should have?
Usually what people think is if I'm outside of Canada, then I do an outside of Canada application. If I'm inside of Canada, then I do an in Canada application. That's not the case. There are a lot of different considerations that go into which one that we do. The overseas is what we call the traditional application. That's the one that the Act actually envisions. And the whole idea was if you marry somebody overseas, then essentially they would put in an application, wait for approval, and then come to Canada as a permanent resident. However, it became a reality that many people met foreign nationals in Canada itself. And so the government designed a program That's called the in-Canada spousal sponsorship. There are a number of considerations that we look at. Okay. The first thing that we always look at, and the number one question that people ask me, is timeline. They all have different timelines, and depending on when you want to get permanent residency, we look at what the timelines are at that time, and we kind of assess based on that. Different visa posts have different timelines, and then the in-Canada timeline also changes quite significantly. So we look at that. The next thing that we look at is appeal rights is a big one. So if you do an overseas spousal sponsorship and something goes wrong in your application, the officer doesn't believe your relationship, or the officer believes that you had gotten into the marriage for immigration purposes, then if you're doing an overseas, you have an appeal right to the Immigration Appeal Division. And those appeals are very strong because you get to go before a board member and plead your case. In Canada applications, they do not have appeal rights. So what that basically means is you can take the decision to federal court for judicial review, and the judge will be assessing whether it was a reasonable decision or not. But the judge cannot accept it for humanitarian and compassionate reasons or anything like that, which the Immigration Appeal Division can do.
For example, if you do it inside Canada, it's denied. Can you then add more evidence and more about the relationship to the federal court?
Unfortunately, you cannot. The
Okay.
federal court is a closed record. So the judge is only looking at what was already before the officer when they were deciding the decision, and based on that, deciding whether the decision was reasonable or not. So we can't add anything more after the decision's been made.
So basically, if someone is applying inside Canada, they have a one shot at getting it right the first time. Whereas if someone is applying outside of Canada, if the first time it's denied, they have a chance later on to go before a board, testify, provide more evidence about the relationship.
Exactly, the Immigration Appeal Division. And then the third thing that we really look at is status. The in-Canada application was very popular because if an individual is in status in Canada, we can also apply for a work permit with it. So essentially that allows you to stay in Canada with your spouse, continue working while the spousal sponsorship is being decided. And this is very helpful to individuals. However, due to changes that were made this summer, the overseas applicants can also apply if they're in Canada legally for a work permit. So that's changed a little bit. The other thing that's really interesting is if your spouse is overseas and you do an application and they're from a visa required country, you can apply for a visa for them to come to Canada, and those are decided on an expedited basis. So they're getting decisions on visas a lot faster than if they're just in the normal stream.
What about the approval rates for these visas? It used to be that if you get married, that then applying for one of these visitor visas, there's such a high refusal rate before. Has there been a policy change recently?
I think that there's been a shift in attitude towards it. There used to be an assumption that if you're married, then you're going to come to Canada and break the law. And I think that there was a lot of consideration, especially given the long timelines, that families were apart. And now officers are kind of looking at something called dual intent. Can you come to Canada as a visitor, so have temporary status, but also have a permanent residence application in place, wanting to also stay for a long period? And I think it was made very clear to officers that they should be considering dual intent. And because of that, we've been seeing more positive visitor visas for spouses.
Good. Excellent. That's all we have today for the spousal sponsorships. It remains one of the really good ways that people who are in Canada, if you're lucky enough to have a partner who's willing to sponsor you and willing and able to sponsor you, remains a very good way to get permanent residence. If you have any questions, we are certainly here to help and help you navigate through a very complicated, it can be very frustrating system, but we'll be here to help guide you along. Take care, everyone.
Happy Valentine's Day. Happy Family Day.
Happy Valentine's Day. Happy Family Day. Bye.